All right. So it is 12 p.m., so we will be getting started. Hello, everyone. Thank you for joining our webinar today. Our webinar today is made possible with the generous support of Justice Canada's Canadian Family Justice Fund. And it's called Getting Married on PEI, What You Need to Know. We are also joined today by with Amber Wilson of Key Murray Law. So thank you, Amber, for being here. And I also want to start with a land acknowledgement. We are gathering on the ancestral and unceded land of the Mi'kmaq, and Epigwit is covered by the treaties of peace and friendship, and we are all treaty people. So I encourage you all to learn more about the treaties and what that means, and you can find more information on Ulnoe's website. So what we're hoping to help you with today is to help you learn about marriage, marriage contracts, and the steps to get married, the difference between marriage and common law relationships, how marriage and divorce affects assets, estates, and healthcare decisions or directives. And we're also going to be providing more information about free family law resources and services, both at Community Legal Information, or CLE. I will be referring to our organization as CLE, and at other service providers. Oh, I missed our agenda. Let me go back. Oops. Yes. So our agenda for today. What we were going to be doing today is I will be introducing CLE, our organization. I will be introducing our presenters, and then Amber Wilson will present on today's topic. And then Stu Rogers and I, a legal navigator here with CLE, we will be going into more details about our organization, our resources, our services and programs that may be helpful to folks watching today, and other external resources and services available. And then we will end with the Q&A session and a survey. So a little bit more information about our organization is that we are a registered charity and not-for-profit here on PEI, and our mandate is to provide islanders with easy to understand information about the law and the justice system. So we do that through several services, programs, and resources, and this webinar today is an example of that. So some information about who the presenters are today. There's myself. My name is Melek Shirin Nassar. I use she, her pronouns, and I am a project manager here with CLE. We also have Amber Wilson, who is a lawyer with Key Murray Law, joining us today to present about this topic and answer questions. And we also have Stu Rogers, who is a legal navigator here with CLE, supporting us and making sure everything goes well, and will also be providing more information about our services. And before I hand things over to Amber, I will provide a short bio. So Amber joined Key Murray Law as an associate in their Mill River and Summerside offices after completing 2 summers and her articles with the firm. Amber is building a general practice with a keen interest in family law, and she's passionate about helping individuals understand and access the justice system. Amber is enthusiastic about bringing a trauma-informed approach to helping clients with their legal problems and is committed to meeting the individual needs of each client. So we will be moving on to Amber's presentation.
Hi, and thank you so much, Malik. It's a pleasure to be here, and thank you to you and to Stu and for CLE for organizing this. And you're good to control the slides? Okay, perfect. So we'll get started then with kind of the agenda on for my presentation. So first, we're going to look at a legislative overview, and that'll just be a quick look at the applicable statutes and legislation that deal with or surround marriage and PEI. Then we'll look at what marriage actually is and what the legal requirements for marriage and PEI are. Third, there we have a that is what the legal requirements are. How do you actually get married? And then fourth, we'll do a brief overview of the primary differences between married and common law couples in this province, including property rights and spousal support. We'll also review what a marriage contract or a prenup is and what those agreements can do and what they cannot do or their limitations. We'll then talk about certain considerations of estate planning that should be undertaken when we're discussing marriage and separation as well. And before we wrap up, we'll very briefly discuss divorce and what the process following the breakdown of a marriage looks like. And then, as Malik indicated, Stu and her will present their portion, and then we'll come back for a Q&A session on the marriage and on any other questions that folks have. So the next slide is what I chatted about with the legislative overview. So obviously there's a whole lot, and we could do a whole presentation on each of these acts, but very briefly, these are the applicable statutes that reference or have to do with marriage in our province. So the Constitution Act there's the Constitution Act of 1876, as well as the Constitution Act of 1982, and these are federal statutes that grant Parliament jurisdiction over issues of marriage and divorce, as outlined in Section 91 of those acts. The jurisdiction of marriage and divorce is with the federal government. However, it gets a little bit wonky because the federal government has everything to do with divorce, and then provincial governments typically have their own legislation related to how marriages can proceed in the province, which takes us to the Marriage Act, which is a provincial act that speaks to who may solemnize a marriage and what the requirements to do so are. It provides information about the application to become a marriage commissioner and who else can solemnize marriage, which includes like a clergy or church member, justice of the peace, or a judge. Then we have the Civil Marriage Act, which is a Canadian federal law. It was enacted in 2005, and this act extended the legal definition of marriage to include same-sex couples. So it essentially legalized same-sex marriage across Canada by defining marriage as a lawful union of two persons to the exclusion of all others. So this act redefined marriage in Canada and replaced the traditional definition that limited to heterosexual couples to just be two persons. And then the Family Law Act obviously does speak to family law and issues of family law, but with respect to married couples, the PEI Family Law Act provides a legislative scheme for the division of family property, including the family home, which we'll discuss in a little more detail later on in the presentation. And lastly, the Divorce Act is the federal legislation that outlines the processes, the procedures for obtaining a divorce following the breakdown of a marriage. This act provides the court with the authority to make decisions about a number of issues that can arise after separation, which includes things like parenting, child support, and spousal support. So in a nutshell, the Divorce Act, when you have a married couple, the Divorce Act kicks in and is the applicable legislation when we're dealing with issues of separation, custody, parenting, stuff like that. And for common law couples or couples who aren't married, that falls under either the Family Law Act or the Children's Law Act. Typically the Children's Law Act, now that that's enacted. But those are the legislative provisions that deal with marriage. So in the next slide, we have what actually is marriage. What does it mean? So as I outlined in the previous one, what's on the screen here is a screenshot from Section 2 of the Civil Marriage Act, which is that federal legislation, and it provides both a description and the legal requirements that need to be met in order for two people to be married. So the marriage definition, again, is the lawful union of two persons to the exclusion of all others. And so to break that down, that essentially just means just two people, that's it. No polygamy. Polygamous marriages are illegal here in Canada. And the two persons, like I spoke to earlier, there's no limits on gender expression or sexuality, just two people who are married. And then marriage requires free and enlightened consent of both parties. And the concept of free and enlightened consent in the context of marriage generally refers to the requirement that both parties to a marriage are willingly and knowingly agreeing to the union without any form of coercion, undue influence, or misunderstanding about the nature of marriage. This principle ensures that each party fully understands and accepts the implications and responsibilities of being married. Um, so in order to get married, there's also limitations on age. So you have to be at least 16 years old to be married. But if you're between 16 and 18, so if you're 16 or 17, you need parental consent to be married. And after 18, that parental consent isn't required. And you can't be married to more than one person at once. So again, you can't have more than one spouse, but you also have to ensure that previous marriages that you've been in are dissolved by divorce or by the death of a spouse. And we'll get in what you need to prove that in order to get remarried in the next couple slides, I think. So the Marriage Act of PEI outlines that an authorized individual, such as a clergy member, judge, justice of the peace, or marriage commissioner, performs the marriage ceremony, and that a license is applied for. So to go to the next one, we'll go through the steps of actually getting married in PEI. So the first step is that you need to find somebody to marry. Again, you both need to be at least 18 or with parental consent 16, 17, and you can't be related to another. So there's not a whole lot of limitations on who you can marry, but they can't be a relative. And then you need to plan your wedding, which comes with all the fun stuff of flowers and cakes and dresses and everything like that. But another really important part of planning your wedding is applying for a marriage license. So that in PEI is done through Access PEI. In order to do that, the first kind of step is to book an appointment by calling one of the Access PEI locations that you want to attend for an appointment. So if you're in Surrey, you go east. If you're in Tignish, you would go to one of the western locations. And so both you and your future spouse have to attend that Access PEI location. You have to provide valid birth certificates, valid photo IDs, details of your marriage ceremony, so including who will perform it, so who your marriage commissioner or who your minister priest will be, as well as your PEI health card if you're a resident. And so this is something that isn't typically the first step of wedding planning. It kind of comes towards the end because I believe there's also an expiry on these licenses. So, and I believe they're good for 3 months. So it's kind of towards the end of your wedding planning that you get this done. You also need to pay $100 for the license fee. And if you've been previously married, you have to have the divorce certificate from the court. That's an original that has the court seal on it. And if you're widowed, you have to provide an original death certificate. At the appointment, you take an oath, which includes that, like, you know that you're not related to each other, that you're honest in your application, and Access PEI will provide you with a package to give to your officiant. So your officiant doesn't apply for the license for you, which I had the pleasure of telling one of our students that's here. She's getting married actually next weekend. And as I was putting this presentation together, I said, "Hey, Megan, what kind of questions do they ask you?" Because I was married back in 2018. I didn't know if it's still the same thing. And she said, "Oh no, like the priest is doing that." I said, "Applying for the marriage license?" She said, "Yeah." I said, "No, girl, you need to do that." So thankfully she had enough time to get that done before her marriage, but it was only like, I want to say a month ago or so ago that she learned that she actually had to apply for it herself. And so that's good to know, because she wouldn't have been able to get like legally married on that day without it. So super important part of the wedding planning process. And then you have your actual marriage ceremony. So the last step there is to get married. So at the marriage ceremony, you exchange vows, including a statement that you know that you're not aware of any legal reason why you shouldn't be married. And there's no real formal or legal requirement for the format of the ceremony. And that obviously depends on it's between you and your spouse, how you want it to look, if you want it to be in a church or wherever. There is, however, certain phrases that your officiant under the legislation has to ensure that they say. And don't worry, like, if you have a marriage commissioner, they've gone through the course, they understand their legal requirements to make sure that that what needs to be done in your ceremony is done. And then at the ceremony, you need two adult witnesses. So they have to be 18 years or older to attend and witness, and they will sign the statement of marriage that your officiant then registers with Vital Statistics. So that is what your marriage officiant will do, but they won't apply for the license for you. They will provide Vital Stats with the marriage statement. So in the next slide, we kind of get into the meat of what probably most of you are here for, which is kind of the difference between married and common law and what the actual implications of marriage are in PEI. And I'm just going to take a quick step before we start this one. So in daily life, there's likely not much different in the lives of couples who are married versus those who live as common law partners. However, at law, the legal significance of marriage is really critical. The difference in the rights and obligations between common law and married couples are extremely consequential, especially if their relationship breaks down. And that subject on its own, like the difference between married and common law couples, could be like a lengthy presentation all on its own. So for the purposes of time today, I've tried to keep it really brief, and certainly if you have any questions, I would expect you would at the end. Feel free to bring those up, but this is a really high level overview of the differences. So in PEI, marriage provides strong legal protection for property rights that common law couples don't automatically have. Under the Family Law Act, married spouses are entitled to an equal division of assets and debts acquired during their marriage, regardless of whose name is on the property. So whose name is on the title to the house, whose vehicle, whose name is registered to a vehicle, it doesn't matter. Common law partners, on the other hand, have no automatic right to share in the property unless their name is on the title, or that they can prove in court that they have contributed significantly through what's called unjust enrichment, which is a principle of equity. So in short, marriage creates clear automatic rights to equal property division, while common law partners have to rely on evidence and legal arguments to claim any share in property that their name isn't on. So that's like the very boiled down version of how things work. And like I said, could be an entire presentation all on its own. But this is the most significant thing that people need to understand about what it means to actually get married versus continuing to stay in a common law relationship. Our law really hasn't evolved with the fact that lots of people build lives together without ever having that like legal document being a marriage certificate that states that they're married, but their intention maybe to share everything upon separation if that were to ever happen, or upon death, but that isn't the case if only one party's name or is on the title or registration or anything like that to personal or real property. So yeah, our law hasn't caught up, which results in situations that I see super common in my day-to-day work. People who have built their lives together with their common law partner, and things go south and they break up, and because one person has kind of accumulated things in their own name, they're left with very little at the end of the day. And the legal, I don't want to say battle, but the legal struggle to make that claim against another person's property is really complicated, and it's really time consuming, which equals very expensive. So it's certainly an area that our laws need to catch up with. In other provinces, like the Western provinces, married and common law property rights are equal, but here that is not the case. So I guess maybe I should have flipped this a little bit to outline what actually married versus common law is. So married, obviously, you are legally married. You've gone through the steps that we've already alluded to in this presentation, and you have that essentially piece of paper that says that you are married. Where common law whether a couple can be considered common law spouses is just dependent on what we're looking at. So, um, some legislation, like the Family Law Act, classifies common law as being in a conjugal, uh, which essentially is a romantic or sexual relationship, and living together for a period of 3 years, or you are living together and you have a child together. So, regardless of how long you've lived together, if you've lived together and you have a child together, you're common law, or under the Family Law Act, if you live together for 3 years, you would be considered common law. And under the Income Tax Act, however, 12 months of living together as a couple classifies you as common law, and therefore you should be filing your taxes as such. So, where the definition of common law under the Family Law Act really comes into play is with spousal support. So, as we've established, property rights, if you're a common law couple, there's no legislation out there that covers what your rights are in terms of your common law spouse's property. There's nothing. It's all based on common law, which is what makes it a really challenging and really expensive process if you guys can amicably decide about what happens with property. But where the definition of common law does come into play under the Family Law Act is with respect to spousal support. So, in order to be entitled to claim spousal support, you have to be considered a spouse under the Family Law Act, which is at either 3 years of living together or having a child together and living together. So, again, could be like a whole entire presentation on its own. But briefly, that's kind of the difference between common law and married with respect, at least to property rights and what that definition means. So, we can move on to the next slide, which is marriage contracts. So, this is also known as prenups, as we often hear them referred to, and they are governed by Section 51 of the Family Law Act. And that section essentially states that people who are married or planning to get married can make a written agreement, which we call a marriage contract, that sets out their rights and responsibilities during the marriage if they separate or one of the spouses dies. So the marriage contract can cover things like who owns certain property or how property is divided, who will pay support. You can also speak to a child's educational moral upbringing, as well as like prenatal costs, birth expenses, funeral expenses, or other personal or financial affairs. However, a marriage contract cannot take away a spouse's, so again, a legally married person's right to the family home. Any part of the agreement that tries to do that will not be enforceable. This exception, though, of the family home does not apply to what are called cohabitation agreements, which are for parties who are living together who are not married. So again, those kind of common law spouses. So because this doesn't apply to cohabitation agreements, this exception about the interest in a family home, they certainly limit those agreements and certainly limit one party's right or interest to the home that both parties live in, but perhaps only one party owns. And most of the time, that's what cohabitation agreements aim to do, is to protect the property of the person who owns it. So another important note is that marriage contracts and cohabitation agreements both cannot deal with parenting time or decision-making responsibility of any children of the parties. So that's something that you can't say that, okay, if we break up, I'm going to have the kids full-time and you're going to see them every other weekend and you're going to pay me support. Cohabitation and marriage contracts cannot deal with that. So in PEI, marriage contracts are not super common, but cohabitation agreements, which basically have the same terms except for that exception with the family home, are fairly common between couples who are living together and who are not married. An important thing to note is that under Section 52(2) of the Family Law Act, if parties to a cohabitation agreement get married, their agreement shall be deemed to be a marriage contract. So kind of the whole like ethos behind cohabitation agreements is that the cohabitation agreement stands while you're living together, and if you decide to get married, it turns into a marriage contract, and if you break up, then it turns into a separation agreement. But because of that limitation on parenting time, on the interest in the family home, it can get a little bit clunky in terms of how that actually plays out. So while the idea of the prenups will form the basis of an agreement, if the parties have kids, things kind of have to be switched around because you can't deal with the like parenting arrangement support within child support, I should say, within a cohabitation or a marriage contract. So oftentimes people will have to amend them or just do a whole new separation agreement. But they would certainly be enforceable with respect to any property rights that have been outlined in the initial marriage or cohabitation agreement. So per the Family Law Act, these agreements have to be in writing and they have to be witnessed by people other than the spouses in order to be enforceable. Further, both parties have to be mentally capable of signing the agreement. And so while you don't necessarily need a lawyer to assist in drafting and executing a domestic contract, which is kind of the umbrella term for cohab, separation agreements, marriage contracts, it's certainly a good idea to do so. And of course, I'm going to say that. But you want to make sure that the agreement is enforceable and fair and that both parties understand what they're actually signing. And so, you know, we as lawyers, we deal with that all the time. And it doesn't look like Greek to us. And hopefully our job is to explain it to the parties as best they can so that they're understanding their rights. If they separate or if either party dies, whatever is in that contract. So that does it for that. And then we'll move on to kind of the last bit of the presentation, which is, or second last, I guess. So we're at the penultimate here, which is estate planning considerations. And this is one of the things that people are often really surprised by, aside in my practice, I found anyway, aside from people thinking that common law spouses have exactly the same rights as married people. That often comes as a shock to people. And the other thing that comes as a shock to people is kind of the impact of your marital status on your estate planning. So Section 68 of the Probate Act, which is the act in this province that governs wills and estate administration and PEI. So your estate planning as well as what happens after you die. So Section 68 states that getting married automatically cancels any will you made before the marriage. So a marriage voids a will is the easiest way that we say that. This rule doesn't apply if you make the will specifically in anticipation of marrying a certain person, and that marriage happens within a month of making a will. So in my wills course in law school, I learned that PEI has among the most restrictive clauses in its legislation with respect to wills being made in anticipation of a marriage. So typically our advice, because you can't, like, if you make a will and you get married, the will is void. It doesn't stand anymore, and unless you do so within 30 days of your marriage, like 30 days before your marriage, and it has to name your fiance, everything like that. So typically our advice to people, if you come into my office today and say I want a will and tell me that you're getting married in December, my advice would typically be, unless you have some sort of health condition or are traveling and really want a will in place, would be to wait until after your marriage, because you would just be doing it again anyway. So with Section 69 of the Probate Act kind of speaks to what the effect of divorce is on a will. So if you make a will and you leave property or gifts to your spouse, and again, spouse being your married partner, or you name your spouse as the executor to your will, or you give your spouse special legal powers in the will, and then prior to your death, your marriage ends in divorce. So you have that document from the court that says this marriage is over. Or in really rare circumstances, a court declares that the marriage was never valid. Like if one person didn't have that that clear consent, then, or unless your will specifically says otherwise. So unless your will says like regardless of whether me and my spouse are still married at the time of my death, I want this gift to happen. So if your will doesn't have any kind of qualifications like that, then those gifts, that appointment, the powers to your spouse are automatically canceled. So your will is then read as if your ex died before you did. However, this is not the case if you are separated from your spouse but not divorced. So it kind of leaves you in limbo a bit with respect to your estate planning. So we always recommend that people who are separated redo their estate planning documents to ensure that if they did die before they got a divorce, their ex wouldn't benefit from their estate, because that's the last thing that you would want, or that your family would want. So kind of the last note on this is that if you don't have a healthcare directive that appoints somebody other than your spouse as your proxy, which is the person that is to make your healthcare decisions for you if you're not able to, then your spouse would be the person to do that per the Consent to Treatment of Healthcare Directives Act. So in the absence of a healthcare directive, then your spouse would make those decisions for you. So again, like if you're separating, we always just advise people to update all of their documents because you don't want your ex controlling you like that. And then for the last slide, we have kind of the breakdown of marriage. And this again could be many presentations all on its own, but at a high level, the breakdown of a marriage is governed by the Divorce Act. And in order to obtain a divorce, you have to meet one of the grounds for divorce. So there's 3 grounds for divorce. There's adultery, or cheating, infidelity, whatever you want to call it. There's mental cruelty. And there's also the most common ground, which is that you've been living separate and apart for a year. So although some or many marriages may end because of adultery or mental cruelty, it is very, very rare for an actual divorce order to be sought on those grounds. This is because the legal process for doing so for seeking a divorce on the grounds of adultery, is time consuming, and it's both financial and mentally draining. So in almost every case, it's better to negotiate the terms of a separation agreement during that year of post-separation that you're waiting to apply for a divorce, rather than proceeding through the courts to have a divorce granted before the 1-year mark. So essentially what that means is that you can apply for a divorce prior to being living separate and apart for a year. If, for example, like the parties aren't able to negotiate a separation agreement, or the matter has to go before the courts quickly to deal with issues of like parenting time or support. Typically, the way to get that into court is to do a petition for divorce, but you cannot, a court cannot grant a divorce prior to the parties being separated for a year, if that's the ground that the divorce is being claimed, which is typically how we do it. If you wanted to seek a divorce on adultery or mental cruelty, you can do that, but it typically requires the other party to admit to that. And if they don't, which not a lot of people are willing to, especially on the mental cruelty part, then it would require a trial, which is where I said before that it's like financially, mentally draining to put yourself in that position of having to prove what your spouse did to you. So typically, the most common course of action is that parties split. They can move. They sometimes move out of the house or find a different place, or sometimes they stay in the same house but are can be considered to be living separate and apart because they're no longer holding themselves out to be a couple, which again, whole other presentation on what separate and apart can mean. But essentially, couples decided that they've split up, and then they outlined what's going to happen with their property, what's going to happen with support, with their kids if they have any in a separation agreement. And that can take like, many years to figure out, or for some couples it's a week and some it's a few months. It all depends on the couples and their personalities and their legal advice, everything like that. So there's no like timeline of when people should get a separation agreement. But when a separation agreement is finalized, then the couple can apply for a petition for divorce. Like once the year has passed since they've separated, and ask that the court grant a divorce based on the terms of the separation agreement, which means that there's no reason for parties to attend court or anything like that. It's kind of often referred to as a desktop or paper divorce, where parties don't need to attend court and like they're not battling things out in a courtroom. It's kind of done all behind the scenes, usually with lawyers, but sometimes not. And so there's lots of different ways that people conduct themselves after a breakup, and it really depends on those kind of intentions and behaviors about how the process goes, whether it goes through the court system or if it's kind of done more amicably through lawyers or by the parties themselves. So some couples are, like I said, not able to reach an agreement, and they have to get the court to determine things. And so that's in terms of like married couples, that sometimes you might hear the phrase like legally separated. So there's no like marital status. Legal marital status is separated. Typically, you're either married or you're divorced, and you are married until you are divorced. But what I've kind of observed in my practice is that people will often refer to themselves as legally separated if they have an agreement in place. And it kind of just makes things a little bit easier. So, but in terms of a marital status, that doesn't exist here. For common law couples, however, because you're not going to get a divorce because you were never married, that separation agreement, or if it's a court order, if you can't agree on one, is the last step. You don't have to go further and apply for anything else. Everything's dealt with within that one. So I think that's it for my portion of the presentation. We'll hand it over to Stu and Malik, and thank you. And I look forward to questions at the end.
Thank you so much, Amber. That was a great wealth of knowledge shared. Thanks so much. So if folks do have questions for Amber, please put them in the Q&A at the button at the bottom of the screen. Stu and I are just going to share some information about our programs and other services and resources, and then we'll head into the Q&A. So if you do have questions, you can put them in there, and we're going to tackle them after this part of the presentation. All right, so I'll get us started with more information about some of the services we offer. So a quick overview of our services, because Stu will go more in depth in just a second. As mentioned, we have many booklets and resources in our legal library. We have a phone line called the Legal Info Line that you can call, and you can ask some of our legal navigators questions. We also have a lawyer referral service. We offer presentations. We have several do-it-yourself kits, including ones for people looking to file an uncontested divorce or create a power of attorney or make a parenting plan. So some of our helpful resources in the legal library that are about family law are, we have a lot of information about family law, and you can find all of these resources on our website, and you can scan the QR code on the corner of the screen there to get there. And I'll give some details about each of the resources that are on the screen here. So our Getting Married webpage, it has information about marriage licenses, marriage certificates, and marriage ceremonies. So again, the steps to get married, you'll find a lot of that information there. It also answers questions about what you need to know if you're getting married on PEI or if you're getting married somewhere else, so not on PEI, including internationally. So some folks usually have questions about if they're getting married internationally, is their marriage recognized? You'll find some information on this webpage. And again, you can access it by scanning the QR code in the corner there. The next one is called Family Law Essentials. So, Family Law Essentials is one of the resources we have that really covers all the basics you would need to know about family law. So, it explains legal terms like spouses or separation or divorce. It also has some information about annulments, division of assets, child support, and um, relocation with your child if you're separated, or international travel with your child if you're separated. So it has a lot of good information there. The next one is parenting and the law. So this one is a bit more specialized into the parenting piece. So it has information that parents would find helpful. So it goes into depth about parenting time, which is the time that a parent spends with their child, or decision-making responsibility, which used to be called custody and access before some changes were made to the Divorce Act. It also has a lot of information about parenting agreements, parenting orders, contact orders, dispute resolution, and again, relocating with or without your child, and child support. The next web page, it's helpful if you have questions about names and birth certificates. So changing your name after a marriage, or changing your name in general, or naming your child. You might find that one helpful. And then lastly, our Resolving Conflict Outside of Court booklet. It's helpful knowing the outside of court options that you have for resolving legal disagreements. So in family law cases, the law says that you must try to resolve the disagreements out of court first, if possible, before going to court. And with that, I'm going to hand it off to Stu to talk a little bit more in depth about our services and our programs.
Thank you, Malik. So these are some of our resources, our services and programs here. We have the legal info line. You can call or email one of our legal navigators for help with a legal question. They can help you explore your legal options and direct you to any helpful resources. You can reach them at 902-892-0853 or by emailing info@legalinfopei.ca. We also have a lawyer referral service if you need legal advice. It offers up to 45 minutes with a lawyer for a $25 fee. It's a one use per issue service, so keep that in mind. Not It's not meant for legal work or representation, so the lawyer can't necessarily look over paperwork or represent you, but they can give you legal advice about your situation. It's not legal aid and it's not an emergency service. It can take up to 30 days to meet with the lawyer through our referral service. Renting PEI, if you have questions about renting, whether you're a tenant or a landlord, they can help answer those questions. They also have very helpful guides for tenants and landlords. Our Justice Avenues program is helpful for racialized people who have questions about family, immigration, or criminal law. So if you're an Indigenous person, a Black person, or a person of color on PEI, you can get legal information and up to 4 hours of free legal advice from a lawyer. We also host several free community legal clinics. And finally, our RISE program. Our RISE program supports people who've experienced intimate partner violence, or sexual harassment at work. RISE clients can get legal information and up to 4 hours of free legal advice from a lawyer. RISE also can refer people to various other services.
Great. Thank you, Stu. So lastly, before we go into the Q&A, I'm going to talk more about some other external resources and services not offered through us. So before getting married, it may be helpful to get access to some financial services because financial issues are actually the leading cause of divorce in Canada. So you might want to speak to a certified financial planner. So they can help you with planning about you and your future spouse's finances, or if you have a lot of debt, you may want to also access credit counseling. So the Charlottetown Debt Consolidation and Credit Counseling might be a good service to reach out to. And then there's also family supports. So some of the helpful family supports, as you can see on the screen, are the Triple P Parenting Program. And this is a free program about healthy parenting approaches, and it's available online and in person. The province also offers a family law navigator service that supports people going through separation or divorce or any family law issues. Family violence prevention services, they offer supports for victims of family violence. They offer outreach services as well as shelter. And then Family Service PEI offers couples and family counseling for folks on PEI. So those are all helpful services to know. And then other services is Vital Statistics. So this is they manage marriage licenses. They also handle marriage certificates and birth certificates. So it's good to know. And then if you're looking for housing, the province has a PEI family housing program that does provide rental housing for families living on low incomes. So that's also something you might want to look into if you are getting married. All right, so we're going to go into the Q&A. So for the Q&A portion, you can ask general questions about family law. It's not for specific legal advice. And again, you can use the Q&A button at the bottom of the screen to ask questions anonymously. We may not be able to answer all the questions during our session based on time, but I think we're doing pretty well on time still. And a disclaimer that any answers provided are general in nature and they don't create a solicitor-client relationship. So let me bring up some of the questions that we have received. So the first question for Amber is, if I own a house and marry someone who lives with me in the house that I own, a prenup would not protect my investment in that property?
Yeah, so that's a great question. The interest in the family home, like I said, like I mentioned in the Family Law Act, typically, and we see it like it's really common. Actually, when I was preparing for this presentation, I realized that I had never actually learned about that kind of exception that is with respect to marriage contracts, which can't purport to limit a person's interest in the family home. And how this plays out, and so yes, like to your answer, yes, it can't fully protect your interest 100%. But how this often plays out is that couples who have a cohabitation agreement will provide for a certain percentage of the increase in the value of the family home throughout the marriage. So if you purchase the property in 2020, you got married in 21, and you divorce or separated in 2030, and throughout that time, the increase in value to the home, say it increased $20,000, your spouse would often, if you made the agreement this way, have an increase to perhaps half the increase in value. And if you couldn't decide on how things should be divided, then it would be up to a court to determine, one, whether the contract or the cohabitation agreement was enforceable as it's written, and two, if it's not, then if it is, then what should it apply, and if it's not, then what interest does your spouse have in it? So it's kind of like it's a tough It's a tough area because most of the time people who have cohabitation agreements don't go on to get married. And if they do, that kind of switch to a marriage contract. Often, if people go through the process of getting a cohabitation agreement with a lawyer, the interest in the family or the family property, and I shouldn't say family property, but the property owned by one partner is in their sole name. Oftentimes that's like the whole point of getting the agreement. And the lawyer will explain to them that exception applies. If they don't, or they miss that, and then say, okay, well, this is a marriage contract. If you guys get married, the couples often won't go back and like revamp the marriage contract to address that. And so they'll just continue on. And then if they do separate, they go based on the cohabitation agreement. And so the party who's not the owner, unless they get legal advice that picks up on that exception, would carry on as that's the intention of the parties. That's a really roundabout way of saying the consequence of being married is so important to highlight because that family home that you live in, things really, really change when you get married versus if you just stay in a common law relationship. If you stay in a common law relationship and it's just your name on the title to the property, it's really challenging for your common law partner to make a claim against that. However, once you get married, that kind of all goes out the window and the provisions of the Family Law Act apply. I hope that answers it. If it doesn't, let me know.
Thanks, Amber. So we have another question. If you expect to inherit something like a family business, but haven't yet, can you stipulate in a prenup that if you divorce, your partner does not gain anything from it?
Yes, absolutely. So that's another big reason why we see cohabitation agreements and marriage contracts is to protect business interests. I practice up west, and so a lot of what we see has to do with fishing assets, and oftentimes those are gifted to people, or to children from their parents. And so, yeah, you can absolutely deal with business interests. And as a kind of aside, generally speaking, any gifts that are provided to you or given to you throughout your relationship or marriage are not included as family property, so not divisible. The qualification of that is what, especially in terms of business, is that the value or the increase in value wouldn't be excluded. So if I'm gifted a lobster license, for example, my spouse doesn't have entitlement to the value of that lobster license on the date I was gifted it. But if I made money off of that lobster license, or or it increased in value over the time, that could be included if we ever split in terms of what my interest in it would be. But the gift itself is excluded.
Okay, great, thank you. So another question is, just a moment. If we have a marriage contract where we got married but move to a different province and get a divorce there, will our marriage contract be enforceable there?
That's a great question. I honestly don't know. It should. The law, you would have to get a lawyer in the province you're in now to make sure that the provisions under which your initial marriage contract were made applying PEI as well. But the thing about marriage contracts is it is a legal contract, and so kind of the principles of contract law apply, which is that like this is the intention of the parties and that should be upheld. So moving provinces wouldn't necessarily invalidate the contract in any way, but it would definitely be good if you're still married to perhaps just give it an update to say that it's your intention that the laws of the province you now reside in or country should should remain, because oftentimes in our cohabs and marriage contracts will put like the governing law is PEI law. But yeah, that can get a little bit messy if you're in a different province or a different country and trying to rely on that. So I would just get some additional legal advice on that from a lawyer like in your jurisdiction.
Great, thank you. So another one we have is, am I responsible for their debts and vice versa? So I'm guessing it's debts that they bring into the marriage.
Yeah.
Would the spouse be
So
responsible for their debts?
say that well we so again could do a whole other presentation on family property at the breakdown of marriage. But essentially, there's a formula within Section 4 of the Family Law Act that outlines how we calculate what we call equalization. So the whole underlying principle within our family law legislation and the scheme for division of property is that the couple, each party to a marriage, leaves the marriage on kind of equal financial footing. So what that often looks like is if one party has a lot more debts and the other has a lot more assets, the person with more assets would pay out the other party to equalize it. And so the quick answer, yes, but the value of your or balance of your debts and the value of the assets on the date of marriage is included, and it's and we look at what you have on the date of marriage as well as what you have on the date of separation. So those two dates and the value of your assets and debts on those 2 dates are kind of frozen in time, and then we do a calculation based on those. So for example, I have a lot of student loan. If my spouse and I break up in 20 years time and I was able to pay off $100,000 worth of student loan, that is a benefit to him. It's a benefit to me because my debt's paid off, but it also would show in our equalization that I benefited from the marriage in that way because I was able to pay off those loans. So it can get a little complicated. And, you know, lawyers, we have like our little Excel spreadsheet that we plop the numbers into, and it comes out with a payment. So if you're trying to figure it out on your own, it can get really complicated. But essentially, like those 2 dates of what you brought into the marriage and what you're taking out of the marriage are the most important when we're looking at what couples will leave with.
Okay, thanks. So this one's a little, it's like there's many questions in there, so I'm gonna try and simplify it. So what happens to assets I bring into the marriage? Are they shared now? What if I don't put them on my will and I die?
Okay. So we can so I think that first part I've kind of covered in the last is that like if you're bringing an asset into the marriage, we can calculate that as an asset on the date of marriage. And then so it's kind of, because we don't typically do like asset by asset, we put them all together as well as your debts. The calculations that we do to figure out an equalization, it's hard to say. It depends on the value and if it increased over the marriage. Essentially, it's like the increase in value through the marriage is what would be divided. And I know that sounds convoluted, but it's really hard to explain without like an Excel sheet to show you guys the how we do the calculation. And then if anything is not mentioned in a will, it becomes what's called the rest and residue of your estate. So lots of people don't have kind of itemized personal items in their will, and they just either deal with maybe a large asset such as a home or a vehicle, and then everything else becomes the rest and residue. And so what we always aim to do as lawyers who are drafting wills is to have a clause which names what we call a residual beneficiary. So that what that looks like is to say I direct my trustee to transfer and deliver all the rest and residue of my estate. So everything that's not mentioned in the will to a certain person. And oftentimes what that looks like for married couples is I direct my trustee to transfer all the rest and residue of my estate to my spouse for his or her own use, absolutely, which just means it's theirs. They can do what they want with it. And then typically we'll provide an alternate beneficiary. So what that often looks like for people with married, who are married and have kids, is that if my spouse dies before me, so then the rest and residue of my estate, so everything that's not listed in my will, goes to my children in equal shares. So oftentimes what ends up happening is it's if you have a couple, it's kind of the last person who survives. Whatever's left when they die splits between their kids. That's often how it goes. But essentially, if you don't list things specifically in your will, then it falls into the residue, which is just kind of the legal word for saying everything else that's not mentioned.
Thank you. Do we need to wait for a year of separation to pass before filing for divorce?
So a court can't grant a divorce before that year if that's the ground that you've applied for. So oftentimes what'll happen, like I said, is that couples will do a separation agreement in that kind of year. And then once the year hits, they file for divorce. If things are not headed towards like a separation agreement that can either be worked out between the spouses or between their lawyers, then you can file a petition for divorce. You don't need to list the ground in that petition unless you're going for mental cruelty or adultery. The petition is just kind of a standard form that the court has that will ask you how long you've been separate and apart. And if it's only 2 months, that's fine. You can still file it if you need your matter to get before the courts in order to, have a decision made about property or parenting time or whatever the case may be. It's just that a court won't grant you your final divorce until that year has expired. I hope that makes sense. So there's nothing stopping you from, the very next day filing for divorce after you separate. But it's just that you won't actually get divorced until a year, unless, of course, you go through one of the other grounds, which I've never heard of another lawyer doing in PEI. Like, it's really, really uncommon.
So, do we have to file taxes together? What does it mean if we do or don't?
Okay, so definitely a question for an accountant, but based on my own personal experience, if so the Income Tax Act is like its own beast and you want to follow it as closely as you can. So if you are living together for 12 months, you should be filing your taxes as common law. And it will, like, so if you're on the lower income side of things, it may impact like your HST rebates, climate change rebates, all those types of things that are based on income. But in the long run, it's too risky to not claim that you're common law, because eventually, if you do, or if, I don't know, CRA takes investigation or something, and you had to pay back any of those benefits that you were receiving that you otherwise wouldn't if you had to claim properly, it's just not worth it. So I know a lot of people tend to kind of be like frightened or afraid to claim common law because they think it's going to impact their returns or the benefits they're receiving. But honesty is the best policy, especially when it comes to the CRA. But if you had any like specific questions, you could ask a tax specialist or accountant about that.
So, it's not really a legal question, but I'll ask, where are all the places that we have to update our records that we are married? For example, do we have to tell the bank?
Oh, that's a great question. So a lot of it, for a lot of people, if they're changing their name, like their last name, they will have, they'll kind of go through, it's a very tedious process of informing all of, basically everywhere that you have some type of account or agreement even with. So like usually it starts with Access PEI. You get a new driver's license, you take your marriage certificate in for that. and then you call like CRA, you kind of go through all the steps of updating your name. But other than that, I think the only thing that really pops up to me would be your insurance companies. So, like your homeowner's insurance, as well as life insurance and auto insurance, just to update, because you know, having a spouse is a material change in like your own personal circumstances, and if you don't disclose that to your insurance company, then they could potentially deny you coverage on that basis that you didn't. So that's the one that really comes to mind for me would be your insurers.
Great.
And one
Thank
thing I
you.
do want to mention before I forget is if you do change your name when you get married and then you decide that after separation you no longer want your married name, you do not need to wait for a divorce judgment to change your name back. You like my maiden name's Walker. If me and my spouse break up and I decide I want to go by Walker again, I'll always be Amber Walker, and I can just go into Access DEI with my birth certificate that says Walker and change everything kind of back that way. It just is kind of what you do when you get married, but in the reverse. But a lot of people think you need to wait until you get divorced to actually change your name, but you don't need to. I could change my name back right now if I wanted to. Yeah, so that's just one other little bit.
Great. Thank you. So the last one we have is, should we move a lease to both of our names if we're renting? What if we don't and one of us dies?
Ooh, I know very, very little about residential tenancy laws. I would say that if you're both paying rent and uh, you're equally responsible for that, then it's probably best practice to for both of you to go on the lease. But I'm not entirely sure what would happen if two people were living in a rental. The party whose name was on the lease died. I think it would probably be contained somewhere in your rental agreement on, if there's any occupants of the property that survive the person who's leasing, they might have a certain amount of like a grace period before they have to leave. But yeah, that's a really good question, and I would probably look into your lease to see if it's required that both of you are on it, or if there's some provisions for if one person passes.
Okay, so that was the last one we have. Do folks have any other questions before we move on?
Those were really great questions. I really appreciate it.
Yeah, that was great. Right. We will move on. Thank you, Amber, so much
Oh,
for
thank
answering
you.
all of
And thank you.
those.
And thanks for everybody who's joining us.
Of course. So the last thing is we do have a survey. It's confidential, and you may be entered to win $100 gift card. And Community Legal Information is also a registered charity. So please donate if you found this webinar helpful. And you can scan the QR codes here on the screen to fill out the survey or to donate. I will also be sending out a post-webinar email that will have a resource sheet with all the services we talked about today, a link to the survey, and other resources we have that you might find helpful. And with that, that is it for today's webinar. So thank you everyone so much for joining us. And this webinar is recorded. We will be uploading it to our website, and please keep an eye out for our social media because we will be hosting more webinars throughout the year. Right. Thanks everyone so much.